All right, the court recognizes that the advisory guidelines would suggest a sentence between 19 months, 38 months on the minimum. The maximum is set by statute at 15 years. The courts can exercise my discretion and sentence consistent with the advisory guidelines, consistent with the plea agreement in this case. It would be the sentence of the court that this defendant serve 38 months on the minimum to a maximum of 15 years with the Michigan Department of Corrections. I'll give him credit for the 30 days that he's served so far. And Mr. Robart, there are some common themes that people have raised here today that certainly share my thoughts in this case, but this tragedy was 100% avoidable. All you had to do was listen to the people in your life that were telling you to put these loaded guns away, and you didn't. The safe storage law received a tremendous amount of attention in Michigan, but we don't need a law to say that it's not safe to have guns loaded or unloaded where they're readily available to children. The pre-sentence investigation report reflects that family members warned you several months to put them away, and you did not, nor did any other adult that was in the house. Your failure to take the most simple safety precautions changed the lives of so many people. The obvious ones are the parents' family, friends, relatives, but we can't overlook what the young man that actually fired the shot, 6 years old, saw what happened. He has to live with that every single day. I can't imagine him going to school. At some point, people are going to know he's the kid that shot somebody, and he's probably going to get teased about it. And then you've got the girl that was there that saw it. She too. Those things are things that no kid should see. They can't unsee those things. Then I think about your wife that was trying to give CPR to the victim, but there's no delicate way to say it. The damages were so bad, she couldn't find his mouth to breathe into. This case, I know, was not easy for law enforcement. I know that several people on the scene, they're haunted by the sight that they saw. It's something that they can't get over. It's something that they can't unsee. And it's something that they shouldn't have to carry either. Your attorney wants this court to believe that you take responsibility for this, but I don't see that. From your statement that you made in the pre-sentence report, that weapon was not loaded when I put it behind the door. The only reason it was loaded was because of the threats against my family. Now, I own guns. I own shotguns. I can't see how a 6-year-old boy with no experience with guns could, number one, find ammunition that was supposedly hidden. Number two, try and figure out how to load a shell into this Remington 870 shotgun, especially since you said that the safety was on. Would have to take the safety off, would have to move the slide forward, would have to feed a shell into the bottom, push it forward till it clicks, and then activate the slide. All those things don't seem possible to me, and they fly in the face of logic. It leads the court to the only conclusion that you left this gun loaded, you knew it was loaded, and all this stuff about it couldn't have been loaded, it had to be unloaded, that's all you trying to minimize or trying to get yourself out of this situation, or have you lived with yourself. That gun was loaded, and you knew it was. So I don't see that you take any responsibility for what happened here. And it's for those reasons that the court has imposed the maximum sentence that I can under these advisory guidelines. The court would direct that your financial assessments would be collected through the inmate account and parole process. You do have the right to make application for leave to appeal your conviction and sentence. If you cannot afford an attorney, the court-appointed attorney to represent you on the appeal, the request for a lawyer must be filed with the court within 42 days. You need to go with Deputy Harmons.